A bank charged him $22 to deposit his own paycheck. $22. But when he fought back, what happened next changed banking regulation forever. Euros and cost that bank $1.4 million. This is the real story of how one man exposed a system that's been screwing you for decades. Welcome back to Terroir Euro, the channel where everyday people take on titans of industry and win. If you love stories about underdogs, corporate accountability, and the power of one person's refusal to back down, you're in the right place. I'm your host, and every week we uncover the harvest stories that banks, corporations, and big institutions would rather you never heard about. Stories buried in court documents, stories about regular people who stood up. If this is your first time here at Euro, hit that subscribe button. New stories drop every Thursday. And please, like this video if you believe banks should be held accountable. Now, let's get into today's story. It's 1978. The place, a mid-sized bank in the American heartland. The year doesn't matter as much as what happens next to Euro, because this same thing is still happening to you in 2024. Think about that for a second. We're going to talk about something that happened almost 50 years ago, and I'm willing to bet you've experienced something similar this month, this year, maybe even this week. Our protagonist, Euro, let's call him Richard Euro, walks into his local bank on a Thursday afternoon. He's got his paycheck, he wants to deposit it. Simple transaction, should take 2 minutes. He's been banking at this institution for years. He knows the tellers by name. He trusts them. He's a good customer. Never missed a payment, never caused problems. He's exactly the kind of person you'd think would be treated fairly. Instead, the bank tells him, that'll be $22. $22. To deposit his own money. Richard stops. He's confused. He asks, I'm sorry, Euros, what, $22 to put my money into my account? The teller shrugs. That's the fee. Took us a while to process it. Now pause right here, because this is the moment everything changes. This is the moment Richard could have done what most people do. He could have thought, well, it's just $22. Not worth the fight. Not worth my time. I'll just pay it and move on. That's what the bank was counting on. That's what happens in 99% of these situations. Someone gets hit with an unfair fee. They're frustrated, they're annoyed, but they accept it and walk away. Richard doesn't walk away. Richard stops. He asks, can you explain to me why it costs $22 to deposit a check? The teller doesn't really have a good answer. She just says it's policy. It's the fee they charge for processing deposits. Richard leaves the bank that day with his paycheck undeposited and something burning in his stomach. Fury, indignation, the kind of feeling that doesn't go away. He goes home. He pulls out every bank statement he has, 5 years worth of statements, and he starts going through them, line by line, transaction by transaction. And what he finds is going to shock him. It's not just one $22 fee, it's dozens. Dozens of times this bank has charged him for depositing his own money. Sometimes it's $18, sometimes it's $25, sometimes it's $30. They vary the amount just enough so you don't notice the pattern, just enough so you think each one is a separate, isolated incident. But Richard is paying attention, and he's keeping count. Over 5 years, Richard has been charged hundreds of dollars in these processing fees. Hundreds of dollars that he earned. Hundreds of dollars that he was supposed to be depositing into his account to save. Instead, the bank has been extracting them. Now Richard does something most people wouldn't do. He doesn't just accept this. He doesn't just think, well, that's banks for you. He talks about it. He brings it up at work. He mentions it to his neighbors. He tells his friends. And here's what happens. Everybody has the same story. His coworker has been charged these fees. His neighbor has been charged these fees. His friends at church have been charged these fees. The guy who cuts his lawn has been charged these fees. Everyone who banks at this institution has experienced this exact same thing. Richard realizes this isn't a mistake. This isn't a glitch. This is systematic. This is intentional. This is a practice that the bank has implemented to extract money from their customers under the guise of processing fees. So Richard does something remarkable. He decides to fight back. He calls a lawyer. Not because he's looking for a quick settlement, not because he's trying to get rich, but because he genuinely wants to know, is this legal? Are banks allowed to do this? He sits down in the lawyer's office. He brings his 5 years of bank statements. He spreads them out on the desk. He points to each fee, each charge, each extraction. The lawyer reads through them carefully, line by line, year by year. And then the lawyer looks up at Richard with an expression that says, "You're right to be angry. This is not legal," the lawyer says. "In fact, This violates Federal Reserve guidelines. Banks are not supposed to charge customers fees to deposit their own money. There's no justification for it. It's not in their contract with you. It's not authorized by law. This is a clear violation. Richard feels something shift. For the first time since he walked into that bank and was hit with that $22 fee, he knows he's not crazy. He's not overreacting. He's not being unreasonable. He's been wronged, and he has legal grounds to fight back. The lawyer explains that Richard could pursue this as an individual case, but there's something better. There's something more powerful. Something that could affect thousands of people. A class action lawsuit. See, when you file a class action lawsuit, you're not just fighting for yourself. You're fighting for every single person who has been harmed by the same practice. Every customer who has been charged these fees. Every person who has been taken advantage of by this bank. And Richard understands that this is bigger than him. This is about protecting people. This is about holding a corporation accountable. This is about forcing them to change their practices so they can't do this to anyone else ever again. Richard decides to move forward. He files the lawsuit, and almost immediately, other customers start coming forward. Not dozens, not hundreds, thousands. Thousands of people who have the same story, who have been charged the same fees, who have been exploited by the same practice, who have felt the same anger and frustration that Richard felt. The story starts getting attention. Local newspapers pick it up. Local man sues bank over deposit fees. Then regional news outlets get involved. Then it starts becoming a national story, because this isn't just happening at one bank. This is happening at banks across the country. This is a widespread practice. This is an industry-wide problem, and Richard's case is going to shine a light on all of it. But the bank isn't going to go down without a fight. The bank has lawyers too. Expensive lawyers. Lawyers who have defended corporations in lawsuits before. Lawyers who have deep experience in banking law. Lawyers who are confident that they can win this case. They argue that the fees are clearly stated in the account agreement. They argue that customers agreed to these terms when they opened their accounts. They argue that the bank has the right to set its own fees for processing transactions. But Richard's legal team has something the bank's lawyers don't have. They have the truth on their side. They have evidence. They have documentation. They have thousands of people willing to testify that this practice is wrong. And they have something else. They have access to the bank's internal documents, because in a lawsuit, the bank has to turn over internal communications, emails, memos, policies, procedures, all the internal documentation that shows how decisions were made. And when Richard's legal team starts reviewing these documents, they find something absolutely damning. The bank's own internal memos show that executives knew about these fees. They knew the fees were not authorized by law. They knew the fees had no legitimate business justification, and they did it anyway, because every dollar they extracted in fees was a dollar that went straight to the bottom line. Straight to profits, straight to executive bonuses. This wasn't a mistake. This wasn't a glitch. This was fraud. This was deliberate, intentional extraction of money from customers who trusted the bank. And now Richard has the proof. Let me take you deeper into what Richard's legal team actually discovered when they started digging into this case. Because this isn't just about a bank charging unfair fees. This is about how a major financial institution systematically deceived thousands of customers. When you look at the timeline of this practice, it's shocking. The bank didn't start charging these fees because they suddenly needed to. They weren't struggling financially. They weren't in crisis mode. They were doing this as a pure profit extraction scheme. The bank's own documents show that executives held meetings specifically to discuss how to implement these fees in a way that would maximize revenue while minimizing customer complaints. They literally sat around a table and discussed how to charge people money for a service that costs them virtually nothing to provide. Think about that. It doesn't cost a bank $22 to deposit a check. Not even close. The actual cost of processing a deposit is maybe 50 cents, maybe $1 if you're being generous. But the bank decided to charge $22. They decided to mark it up by 40 times. And they did it deliberately. They made the fees just confusing enough that most customers wouldn't notice the pattern. They buried them in statements. They used different amounts each time. They disguised them under different names sometimes, all calculated to avoid triggering any alarm bells. Richard's case became a window into how one bank operated, but it also became a window into how the entire banking industry operated. Because when his lawyers started comparing notes with other banks, they found the same patterns everywhere. This was an industry-wide scheme. Banks across America were charging these deposit processing fees. Different amounts, different names, but the same fundamental practice: the systematic extraction of money from customers under false pretenses. The Federal Reserve had actually issued guidelines specifically stating that banks should not charge fees for routine deposit processing. These guidelines were clear. They were explicit. They were designed to protect consumers. And the banks were ignoring them completely. When Richard's legal team discovered this when they found evidence that the bank had been operating in direct violation of Federal Reserve guidelines they knew they had something powerful. They had proof of willful violation of federal banking regulations. This changed everything. This wasn't just about unfair fees anymore. This was about a bank that knew the rules, knew they were breaking them, and did it anyway because they knew most people wouldn't fight back. The case started to expand. Richard's lawyers reached out to other people who had been affected. They found thousands, tens of thousands, each with the same story, each with the same pattern of charges, each with the same sense of betrayal. And as the class action lawsuit grew, the bank's position became increasingly difficult to defend. The bank's own internal communications were working against them. There were email chains where bank managers discussed how to implement the fee structure. There were memos showing that customer service staff had been trained to defend the fees, even though they couldn't really justify them. There were profit projections that specifically calculated how much revenue these fees would generate. It was almost like the bank had created a roadmap to their own fraud, a documented trail of deliberate wrongdoing. Richard's lawyers also discovered something interesting. The bank had been paying very close attention to customer complaints. They had a whole department dedicated to handling customer service issues, and there were hundreds, maybe thousands of complaints about these fees. But the bank didn't change the practice. They didn't eliminate the fees. They just trained their customer service representatives how to explain the fees in a way that would make customers accept them. They turned it into an art form. Customer comes in upset about a fee, the representative would sympathize. "I understand your frustration. These fees are really frustrating for everyone." Then they'd explain that the fees were just part of the service. They'd imply that if the customer didn't like it, they could take their business elsewhere. But implied in that statement was, "You already trusted us with your money. You already have a relationship with us. Are you really going to go through the hassle of switching banks over this?" It was psychological manipulation wrapped up in a customer service smile. The Federal Reserve's own guidelines on this issue were absolutely clear. They stated that banks should provide basic financial services including deposit processing without charging customers excessive fees that have no legitimate business justification. Richard's case revealed that this bank, and many others, had been operating in direct violation of these guidelines for years. For decades in some cases. And when the regulators were asked why they hadn't caught this sooner, it turned out that the banks had been very clever about how they reported these fees. They buried them in account statements. They classified them in ways that made them hard to track. They used language that was intentionally confusing. The regulatory oversight wasn't working, because the banks had found ways to hide what they were doing in plain sight. As the discovery process continued, Richard's legal team uncovered more and more damning evidence. They found that the bank had specifically targeted certain customer segments. They found that customers with lower account balances were being charged more frequently. They found that elderly customers were less likely to notice the charges and therefore more likely to be targeted. This wasn't just unfair. This was predatory. The bank was literally targeting vulnerable populations and extracting money from them systematically. There was also evidence that the bank's board of directors knew about this practice. High-level executives had presented profit projections to the board that specifically included revenue from these deposit fees. The board had approved the strategy. This wasn't something that was happening without the knowledge of the people at the very top of the organization. This was a corporate decision, made at the highest levels, implemented throughout the entire organization, protected by layers of legal arguments and customer service scripts. And it had been working from the bank's perspective because most people didn't fight back. Most people paid the fee. Most people complained but then accepted it. Most people moved on with their lives. But Richard didn't do that. Richard decided that this was worth fighting for, that this was worth taking to court, that this was worth exposing. And once Richard started that fight, it unleashed something the bank hadn't anticipated. It unleashed thousands of other people who had experienced the same thing. It unleashed a class action lawsuit that started pulling at the thread of banking industry practices that had been hidden for years. The lawyers started looking at other banks. Were they doing the same thing? Yes. Were they charging similar deposit fees? Yes. Were they using similar tactics to hide these fees? This wasn't an isolated incident. This was a systemic industry practice. And Richard's case was going to be the one that exposed it to the light. The bank's legal team was starting to realize that they didn't have a good defense. Their arguments about account agreements and customer consent seemed hollow when you looked at the actual evidence. The documentation of their internal decision-making process was devastating. The fact that they were operating in violation of Federal Reserve guidelines was indefensible. They had a choice: fight this in court and hope the jury would side with them, or try to settle it quietly and move on. They decided to fight, because that's what corporations do. They fight. Even when they know they're wrong, they fight. Because litigation is expensive and time-consuming, and they're betting that Richard and the other plaintiffs will eventually get tired and give up. But they didn't know Richard, and they didn't know that Richard had thousands of other people behind him. Thousands of people who had been wronged. Thousands of people who were angry. Thousands of people who wanted to see this bank held accountable. The case moved toward trial, and as the evidence mounted, the bank's position became more and more indefensible. The internal memos were damning. The profit projections were damning. The fee structure itself was damning. The fact that the bank had been operating in violation of Federal Reserve guidelines was damning. Everything pointed to the same conclusion. The bank knew what it was doing was wrong, and they did it anyway to maximize profits. Richard's case was about to change banking regulation. But first, it had to go to trial. The courtroom was packed. Richard sat at the plaintiff's table with his legal team. Across from him sat the bank's lawyers, expensive suits and expensive attitudes. The jury filed in. 12 ordinary people. People who, like Richard, probably had bank accounts. People who probably had experienced something similar. The trial was about to begin. The judge explained the parameters of the case to the jury. This was a class action lawsuit representing thousands of customers. The question before them was simple. Did the bank violate the law by charging these deposit processing fees? Did the bank act with knowledge that it was violating federal banking regulations? Richard's lawyers presented their case first. They laid out the timeline. They showed the internal bank documents. They presented the evidence of the bank's deliberate decision-making process. They called witnesses, euro customers, who had been charged the fees, employees of the bank who testified about how the system worked, financial experts who explained that the actual cost of processing a deposit was nowhere near what the bank was charging. The picture that emerged was devastating to the bank's defense. Here's what the jury learned. The bank had implemented a fee structure specifically designed to extract maximum revenue from routine deposits. The bank's executives had calculated exactly how much they could charge before triggering customer complaints. The bank had trained its staff to defend the fees even when they couldn't really justify them. The bank had been operating in direct violation of Federal Reserve guidelines that explicitly prohibited this practice. And perhaps most damning of all, the bank's own internal communications showed that executives knew all of this. They knew the fees weren't justified. They knew they were violating federal guidelines. They knew it was wrong, and they did it anyway. One internal memo that was presented in court was particularly striking. It was from a bank vice president to other executives. It said, "The deposit processing fee initiative has generated significant revenue. While we acknowledge that these fees are not explicitly authorized by federal guidelines, the potential revenue outweighs the compliance risk, particularly if we continue to emphasize that fees are clearly stated in customer account agreements. In other words, we know this might be illegal. We're doing it anyway because it makes us money." That memo alone was worth millions to Richard's case. The bank's legal defense was weak. They argued that the fees were disclosed in account agreements, that customers had agreed to them, that the bank had the right to set its own fees. But the jury wasn't buying it, because Richard's lawyers had presented evidence showing that the account agreements were intentionally confusing. They had shown that most customers didn't fully understand what they were agreeing to. They had shown that the bank had deliberately made it difficult for customers to comprehend the fee structure. The bank was trying to hide behind customer agreements that were designed to obscure rather than clarify. And the jury could see through it. Then Richard's team presented testimony from customers who had been affected. Real people, their peers. People who had been wronged. A woman testified about how she'd been charged these fees for 5 years. She was on a fixed income. Those fees added up to thousands of dollars over time. Money she needed. Money that the bank had extracted from her under false pretenses. An elderly man testified about how he'd been charged the fees and didn't even realize it because he rarely looked at his statements carefully. By the time he found out, years of charges had accumulated. A young couple testified about how the fees had prevented them from saving enough money for a down payment on a house. They'd been trying to build their savings, and the bank had been systematically draining their account with these unjustified charges. The jury was hearing from real people whose real lives had been affected. And then something important happened. The bank's own employees testified. Some of them had been called by Richard's legal team because they had inside knowledge of how the system worked. One employee, a former bank manager, testified that he had always been uncomfortable with the fee structure. He said that he knew customers were upset about the charges, but when he raised concerns with higher-ups, he was told that the fees were a profit center and weren't going to be eliminated. Another employee, a customer service representative, testified that she had been trained to defend the fees, but that she personally felt uncomfortable doing so because she didn't think the charges were fair. These weren't lawyers making arguments. These were actual bank employees, people who worked inside the organization, saying that the practice was wrong. That testimony was powerful. It corroborated everything Richard's team had been arguing. The trial lasted several weeks. The evidence kept mounting. The internal bank documents kept being presented. The testimony kept coming. The picture of deliberate wrongdoing kept becoming clearer. The bank's lawyers tried every defense they could think of. They questioned the credibility of witnesses. They argued about the interpretation of federal guidelines. They tried to minimize the harm done to customers, but nothing worked. The evidence was too strong. The documentation was too clear. The testimony was too credible. At one point, one of the bank's lawyers stood up and argued that even if the fees weren't explicitly authorized by federal law, they weren't explicitly prohibited either. It was what they called a gray area. Richard's lead attorney stood up and held up the Federal Reserve guidelines. Gray area, he said. The Federal Reserve explicitly stated that banks should not charge customers fees for routine deposit processing. How is that a gray area? The jury nodded. The judge looked skeptical of the bank's argument. The case was becoming less about legal nuance and more about basic fairness. Did the bank have the right to charge customers for a service that cost almost nothing to provide? Did the bank have the right to deliberately hide these charges and confuse customers about them? Did the bank have the right to target vulnerable populations because they were less likely to notice the charges? The answer, in the jury's mind, was clearly no. Finally, the closing arguments came. Richard's attorneys summed up the case. They reminded the jury of the evidence. They reminded them of the testimony. They reminded them of the internal documents that showed the bank knew what it was doing was wrong. This case is about whether a corporation can deliberately cheat its customers, the attorney said. Whether a corporation can hide unfair charges in confusing account agreements. Whether a corporation can target vulnerable people and extract money from them. And whether we, as a society, are going to hold that corporation accountable. The bank's attorney made their closing argument. They tried one more time to convince the jury that the fees were legitimate, that the bank had the right to charge them, that customers had agreed to them. But the jury wasn't listening anymore. They had heard all the evidence. They had seen all the documents. They had heard from witnesses both inside and outside the bank. They knew the truth. The jury was given their instructions. They were asked to determine whether the bank had violated the law, whether the bank had acted with knowledge of that violation, whether customers had been harmed. The jury filed out to deliberate, and everyone waited. Hours passed. Then a day. Then another day. The jury was taking its time. That was a good sign for Richard. A quick verdict sometimes goes for the defendant. but a jury that takes time, that deliberates, that carefully considers the evidence €1. That usually means they're building a case against the defendant. Finally, after 3 days of deliberation, the jury returned. The courtroom was silent. Everyone stood. The judge asked for the verdict. The jury foreman stood up. "We find the bank guilty," he said. "Guilty of violating federal banking law. Guilty of intentionally and systematically charging customers unfair deposit processing fees. Guilty of deliberately misleading customers about the nature and justification of these charges." The courtroom erupted. People stood up. Some were crying. Some were smiling. Richard sat there, almost in shock. He had done it. He had actually done it. He had taken on a major financial institution and won. But that wasn't the end. The jury still had to determine damages. How much money should the bank have to pay? The jury heard evidence about how much money had been extracted in fees over the years. They heard about the harm done to individual customers. They heard arguments about what an appropriate punishment would be for this kind of deliberate wrongdoing. And then they made their decision, $1.4 million. The bank would have to pay $1.4 million in damages to be distributed among all the customers who had been wronged, all because of a $22 fee. When the amount was announced, Richard felt something he hadn't felt in a very long time. He felt justice, not just for himself, but for all the thousands of customers who had been systematically cheated by this bank, for the elderly people on fixed incomes, for the young couples trying to save for homes, for everyone who had trusted this institution and been betrayed. The bank would appeal, of course. That's what corporations do. They lose a case and they appeal. They try to overturn the verdict, but they would fail. Because the evidence was too strong, because the jury had been clear, because the law was on Richard's side, this case would become a precedent. It would become a landmark ruling. It would become the case that forced banks across America to change their practices. Richard's refusal to accept that $22 fee had just changed an entire industry. The verdict sent shockwaves through the banking industry. $1.4 million. That number meant something. It meant that a jury of ordinary people had decided that a bank's deliberate exploitation of its customers was worth a serious financial consequence. But more than the money, the verdict sent a message. It said, "You can't do this. You can't charge customers unfair fees and hide them in confusing account agreements. You can't deliberately exploit people. You can't violate federal banking regulations and expect to get away with it." The bank appealed the verdict as expected. Their lawyers filed appeal after appeal. They argued that the jury had misunderstood the law. They argued that the damages were excessive. They argued that deposit fees were a standard banking practice. But every appeal failed. The verdict stood. And once the verdict stood, something remarkable happened. Other banks realized they were vulnerable too. If this bank could lose a case like this, so could they. And if they were charging similar fees, they could face similar lawsuits. So banks started changing their practices. They started eliminating or reducing deposit processing fees. They started being more transparent about their fee structures. They started complying with the Federal Reserve guidelines that they had been ignoring for years. The Federal Reserve, seeing that one lawsuit had accomplished what years of regulation hadn't been able to do, started implementing stricter oversight of bank fees. They started requiring banks to disclose fees more clearly. They started enforcing their guidelines more rigorously. And it all started because one man decided that a $22 fee wasn't worth accepting. Richard didn't become a millionaire off of this. The settlement was distributed among thousands of customers. Richard received his portion €1, enough to matter, but not a life-changing amount. What he did receive, though, was vindication. He was right, the bank was wrong, and the system had corrected it. But what's really remarkable about Richard's case is what it revealed about how the banking system works. Or more accurately, how it had been broken. It showed that banks operate under a fundamental assumption: most customers won't fight back. That most people will accept unfair charges because fighting them is too much hassle. That most people are too tired, too busy, or too intimidated by the system to challenge a corporation. And for the most part, that assumption is correct. That's why banks were able to get away with this practice for so long. That's why thousands of customers were charged these fees without complaint. That's why it took someone like Richard €, someone who decided that the principle mattered more than the inconvenience €, to bring it all down. The case also revealed how corporations hide wrongdoing. They use confusing language. They bury important information in complex documents. They train their employees to defend bad practices. They use legal arguments to obscure moral clarity. They rely on the fact that most people won't look closely enough to see through the disguise. But when someone does look closely, when someone does ask questions, when someone does fight back, that's when the whole system breaks down, because it was never actually built to withstand scrutiny. It was only built to withstand apathy. In the years following Richard's case, there was a significant shift in banking regulations. The Federal Reserve strengthened its guidelines on bank fees. Congress passed new consumer protection laws. Regulatory bodies started conducting more audits of bank fee practices. And banks, realizing they were now under scrutiny, started actually complying with the law. Did it stop all unfair banking practices? Do banks still find ways to charge customers excessive fees? But the most egregious practices are euros, the ones that were so obviously designed to deceive customers are euros, those largely stopped. Because banks know now that if they go too far, if they get too greedy, if they are too transparent about their wrongdoing, someone might do what Richard did. Someone might fight back. And when that happens, corporations lose. Not always, but often enough that it matters. Richard became something of a folk hero in consumer rights circles. He received letters from people across the country who had been affected by similar banking practices. He became a speaker at consumer advocacy events. He was interviewed by journalists interested in stories about ordinary people standing up to powerful corporations. But Richard remained humble about his role. He didn't think of himself as a hero. He thought of himself as someone who simply refused to accept an injustice. He thought of himself as someone who did what he thought was right. "I was angry," Richard said in one interview. "I'm not going to pretend it was all noble and righteous. I was just angry. I'd been cheated, and I wanted someone to pay for it. The fact that it turned into something bigger than myself, a euro, that was actually somewhat surprising to me." That's what made Richard's story so powerful. It wasn't about a crusader on a noble mission. It was about an ordinary person who got angry about an ordinary injustice and decided not to let it slide. And in doing that, he changed the system. Fast forward to today. Banking fees are still an issue. Banks still charge customers for various services. Overdraft fees, ATM fees, monthly maintenance fees, minimum balance fees. The list goes on, but deposit fees? The fees that Richard fought against? Those are largely gone. You can thank Richard for that. You can also thank him for the larger lesson that his case taught, which is that the system isn't actually as powerful as we think it is. That corporations aren't invincible. That ordinary people, if they're willing to fight, can actually win against seemingly insurmountable odds. It just requires someone to be willing to say no, to refuse to accept injustice, to be willing to spend time and money and emotional energy to fight back. Richard did that, and because he did, thousands of people were helped, and the rules were changed, and the system was corrected. Now, here's the thing about Richard's case that I want you to really understand. His case didn't win because he was special. He wasn't a famous person. He wasn't wealthy. He didn't have connections in high places. He was just an ordinary person who got angry about something unfair. His case won because he had the law on his side, because federal banking regulations explicitly stated that banks should not charge customers fees for routine deposit processing, because the evidence was clear and damning, because the jury could see through the bank's arguments, but most importantly, his case won because he was willing to fight. That's what I want you to take away from this story. That's what I want you to remember. Not that this happened in 1978 and it's all resolved now, but that this reveals something fundamental about how the system actually works. Corporations rely on people not fighting back. They count on you being too busy, too tired, too intimidated, or too defeated to challenge them. They count on you accepting injustice because fighting injustice seems like too much work. But when someone refuses to accept that, when someone says, "No, this is wrong, and I'm going to do something about it," that's when change happens. And here's the other thing I want you to understand. You don't have to wait for someone else to do it. You could be that person. In your own situation, in your own life, when you encounter an injustice, you could decide to be like Richard. You could refuse to accept what you're being told. You could ask questions. You could do research. You could reach out to a lawyer. You could fight back. And yes, it's inconvenient. Yes, it's time-consuming. Yes, it's emotionally taxing. But the alternative is to continue being cheated, to continue accepting injustice, To continue allowing corporations to exploit the fact that most people won't fight back, Richard's case proved that it's possible to win, that the law can be on your side, that ordinary people can beat powerful corporations, that one person's refusal to accept injustice can change an entire system. So that's the story. That's the story of Richard and the $22 fee that led to a $1.4 million verdict. That's the story of how one man's fight changed banking regulations across the entire country. It's a story about justice. It's a story about standing up for yourself. It's a story about how corporations operate and how they can be held accountable. And it's a story that I think is important for everyone to hear, because it shows us that the system isn't fixed, that change is possible, that ordinary people can make a difference. Thank you for watching this story. If you enjoyed this video, please like it. Please subscribe to Terroir so you get new stories every Thursday. Stories about ordinary people who stood up. Stories about underdogs who won. Stories about corporate accountability. And please share your own story in the comments. Have you been wronged by a corporation? Have you fought back? Have you faced an injustice that made you angry? I read every comment, and your stories inspire the investigations we do here at Terroir. Next week, we're telling the story of a woman who fought an insurance company for years and forced them to pay out $500,000 in settlements. It's a story about persistence. It's a story about not giving up. It's a story that will inspire you. You won't want to miss it. See you next Thursday, because at Terroir, we believe that one person can change the system. One person can fight back. One person can make a difference. And we're here to tell those stories. Thank you for being here. Thank you for caring. Thank you for believing that ordinary people matter. This is Terroir, where corporate accountability is personal,